phone, but you do not have to make a statement. If you elect to remain silent and you have not entered a plea, we will enter a plea of not guilty for you, which will move this to the next phase, which is likely a pretrial, but you also have a right to a trial. The trials are before me, which are called bench trials, unless you have the type of case and make the request in writing for a jury trial. Before either trial, we will make sure that you know the evidence against you. At the trial, you can cross-examine any witness that the city calls, and you can have your own witnesses appear. And if your witnesses won't come based on you making that request, we will subpoena your witnesses for you. In addition to the right to remain silent and the right to a trial, you have a right to an attorney, which is why there's always a delay in the morning to make sure whoever needs to speak with the defense attorney has that opportunity. If you have not, we'll make sure you get a chance. But if you would like to hire your own attorney, let me know that, and I'll give you a chance to come back with your own attorney. When I call your name, there are 4 types of pleas you can enter in any court. The first one is that not guilty plea, which resets this for another hearing or a trial. You can also enter a plea of guilty where you are admitting what you're accused of. And if you do that, I could sentence you today. A sentence in a municipal court ranges from $0 to $1,000, 0 days in jail, up to 6 months in jail. That's the jurisdiction of this court. That's on a guilty plea or guilty finding. We can also reach that same conclusion on a no contest plea. No contest is similar to guilt in that we can get your case resolved, but the difference is you're not stating with your own words that you're guilty, but you're not contesting the allegations against you. That means that plea cannot be used against you in a later proceeding. And then there's a plea of not guilty by reason of insanity. If you choose that particular plea, we would have to stop these proceedings to see where you are in your ability to go forward. But keep in mind that plea is not available for your traffic cases. Moving to your traffic cases, if you're going to resolve a traffic case here today, and if you get points, the BMV will be notified of your points. If you accumulate 12 or more points in your license will be suspended, and driving under suspension, a 12-point suspension, in Ohio is a jailable offense. So it's important to know where you are in regard to your points. Also, you must have insurance to drive. So if your ticket is marked no for insurance, you're going to receive a suspension from the BMV. However, if you are able to come back within 72 hours, show your insurance, we'll update the file. That way you may avoid that particular suspension. You also have 72 hours to take care of your fines and costs. Remember, I said they range between $0 and $1,000. If you resolve your case today, we'll tell you what the fine is. You go to the clerk's office, they'll tell you the total. If you can't handle it today, within 72 hours, you can come back and request a payment plan. The only thing that I require is that you make some type of down payment toward your fines and costs. You show that effort, I will extend the balance out. The last thing I want to mention is you may be here on a felony charge. And if that's your situation, you still have a right to an attorney. You have the right to know the charges against you. You have a right to a bond, and you have a right to what's called a probable cause or preliminary hearing. That's a hearing where the city has to put on some evidence to indicate that a crime was committed in East Cleveland that is a felony and that you're connected to it. Not that you're guilty. They do not have to prove your guilt, but if they can make the connection, basically what they're doing is telling me that this is a misdemeanor court, you're charged with a felony, and I have to send it to the county. The other way for the case to get to the county is for you, after speaking with your attorney, is to waive that hearing, understanding that the case will be sent to the county, but you are not admitting any guilt. All right, if there are any other questions, I'll answer them when they come up, or the defense attorney or prosecutor can assist you. Thank you for your patience. All right, the first case is 20 CRA 00098. Is it McQuan Goolsby? Goolsby, come on up. And counsel, how are you?
How are you?
Excellent. So counsel, once you make it over there, state your name for the record.
Patrick Senish here on behalf of Mr. Goolsby.
All right. Counsel, I have here that your client is charged with having a weapon while under a weapon while under disability. This occurred on or about January 31st, 2020. That is a felony of the 3rd degree where he's looking at 9 to 36 months and up to a $10,000 fine. Their complaint is stating that he did have a firearm in his immediate control while in a motor vehicle. The disability would either be a previous conviction or an indictment of another charge. Counsel, how are we proceeding today with the preliminary hearing?
My client wishes to waive the preliminary hearing.
Okay, so we will go ahead and do that, and I note that he's out on bond, so that will continue. Now, counsel, we normally set the first appearance date from here, and that would be on this Monday, correct, President Sanders? So the first appearance would be Monday, the 10th, the 12th floor of the Justice Center at 9:45. Bond is continued, and other than that, we're done. All right, take care. Good luck, sir. then he was when I was here. It was really weird. 20 CRB 00058, John Moore. Council, good morning.
Morning, Judge. I'm James Levin.
Thank you very much. All right, it looks like this was a charge of unauthorized use of a motor vehicle, and I'm going to hear from Ms. McCullough because it looks like this is going to be, instead of a first-degree misdemeanor, you're dismissing it cost only, correct, Ms. McCullough?
Yes, this was a matter where the party who owned the vehicle was deceased. She passed the vehicle on to another family member. At some point, the vehicle was reported stolen. It was confirmed stolen, and they pulled him over. But later communications, they don't wish to prosecute.
Okay, all right. So, counsel, anything to add to that?
Well, Your Honor, there was a mistake, I believe, of who was handling an estate and who had permission to drive the car for the decedent.
Okay.
The defendant was 64, a resident of East Reading, with no criminal record whatsoever.
All right.
Never considered that way. He did not have permission to drive the car, which was loaned to him by his partner.
Okay. All right. So, Mr. Moore, I'm going to accept the dismissal at cost only. You just take care of the court costs and everything is fine. Any questions, sir?
No. Yes.
All right. Well, take care. Thank you.
Thank you.
See, again, I give you and Orlando a speech, right? But I still can't look to the right. I'm flawed, man. I'm not perfect, bro. I just don't want to, man. At least I know. I own mine.
Terrell Thompson. Mr. Thompson is 20 TRD 00254. Mr. Thompson, this is alleging that on or about January 19th, there was a speeding violation, 43 and a 25 Superior in North Lockwood area. You've shown insurance today, and it looks like what the city prosecutor has done is amended the charge to a no-point violation of unsafe motor vehicle, which will keep you good with insurance. Is that your understanding?
Yes.
All right. To that amended charge of unsafe vehicle carrying no points, how do you plead? Okay, I'll accept the no contest plea with the finding of guilt. It's a $200 fine plus costs. If you need time to pay, we can work with you. They'll give you the details at the clerk's office. Yes.
Is anyone who community service?
You know what? Right now, we do not offer the community service for traffic violations, but I will tell you this. There's some information you can fill out at the clerk's office indicating where you are financially. That may come available only because just recently one of the councilwomen spoke with me about some needs around the community. That may happen, but generally speaking, we normally set up an extended payment plan to help you out. But go ahead to the clerk's office. They'll tell you what you owe. You can ask for the form to fill out to give me more information. We'll go from there. All right. Take care, sir.
Do we have Jackson's case attorney in the back?
Have you spoke with the prosecutor, Mr. Jackson? Okay. All right. Nadine Zaire, is it Zahir? Zahar, okay. 20 TRD 00402. This is from January 26th, alleging that there was a traffic control device that was not adhered to. You did show insurance. And I see here that you have an agreement with the city prosecutor where this will be dismissed at cost only. Is that your understanding? Okay. So I'm going to go ahead and accept the agreement that you have. It'll be no points, no violation, just the court costs. You just go to the clerk's office. All right, you take care. All right, 16 TRD 01094, Tajania Hamilton. This is from May 12th, 2016, a driving under suspension and a sunscreen. Counsel, good morning. Name for the record. All right. Counsel, it looks like this was initially a driving under suspension, and I didn't get a chance to mention it in the beginning, but normally that's a 2-point violation. Your license could be suspended for an additional period of time. Some judges even give jail time for driving under suspension, and the fines range from $500 up to $1,000. So driving under suspension is a very expensive violation. But what I have here is that your attorney worked out with the prosecutor to amend the charge to failing to display your license. That doesn't carry any points. It doesn't carry suspension. It lowers your fine. And the other charge is going to be dismissed. Is that correct, counsel?
Yes, you're right.
All right. So to the amended charge of failing to display the license, how does your client plead? All right. And Counselor, is there a consent to a finding of guilt?
Yes, sir.
All right. So I'll accept the plea as opposed to the $500 fine. I'm going to cut that in half. It'll be $250 plus costs, no points. The other charge will be dismissed, and if you need time to pay, we'll work with you. All right. Thank you, Counsel. Take care. Nice seeing you. Any other attorneys? Okay. Tiffany Gilbert, 19 TRD 02691. Ms. Gilbert, this is from July 3rd, 2019, alleging of driving under suspension, plate violation, and a stoplight. It looks like you've shown insurance. You did that, I think, at a previous court hearing, so we have that information. Looks like the prosecutor agreed with you to amend this charge to no driver's license. Is that your understanding? And what they would do is dismiss the remaining charges. So to the charge of no driver's license, how do you plead? I'll accept the plea with a finding of guilt. Because that is amended from driving under suspension to no driver's license, I'll give you the same courtesy of cutting that fine in half for you, so it'll be $250 plus cost. And as I mentioned, everything else is being dismissed. So you just go to the clerk's window, okay? Take care. Dayon, is it Dayon Collins?
Yeah.
Come on up, sir. 20 TRD 00367 is a driving under suspension and traffic light from January 26th, Taylor and Terrace area. Looks like what the city has done for you is change the traffic light to a non-moving violation so that you don't get any points, and dismissing the suspension charge, correct? All right. How do you plead to unsafe motor vehicle? I'll accept that plea. It's a $200 fine, no points, and the driving under suspension, which would have been a much more serious financial damaging offense, has been dismissed. So you just go to the clerk's office, all right? Take care. Andrew Hatcher. Mr. Hatcher's case is 10 CRB 00931. From August 8th, 2010, alleging that there was an open container. Mr. Hatcher, it looks like you worked out with the city that this is going to be dismissed at court cost only, correct?
I was going to ask about the court cost.
Mhm.
They, also, I've been, with Harper Light, and recently they told me to get a job. I did it just for saving money, and then I had to deal with child support services.
Okay.
Save my money up. Then child support took my over $1,500. Cleaned my account out, took all my money out of my bank account.
How long have you been with Harbor Lights?
I've been there since July.
Okay. And how's that been working out for you?
It's been working out good. I got certificates here. I completed my OP, aftercare.
Okay.
I've been an employee of the month in October on the job I'm working at.
All right. Well, congratulations on that. For me, that's more important than the fines and costs. So I will go ahead and do that. So basically the case will be dismissed in its totality. So you're free to go. No fines, no costs.
Oh,
Keep up the good work, all right?
well, thank you very much.
You're welcome. Take care. No, this is it. Yeah. I don't even know what's going on with this one. Did he pay for it? So how can I make him? We would owe him money. Huh? We would owe him money. No, I'm saying if we vacate it. Okay. All right. 16 TRD 04082, the City of East Cleveland versus Marcus Morgan. Counsel, good morning.
Your Honor, good morning. Mark Dawson, on behalf of Mr. Morgan.
Counsel, I know we have a chance to make a record as to what you're requesting.
Your Honor, thank you. I appreciate that. Judge, Mr. Morgan had a case out of Cleveland Municipal Court, which is where I first encountered him. I worked for the public defender's office. That case was dismissed when no one showed up for trial. Judge, that particular suspension stems from a 2016 headlight ticket he occurred within the city of East Cleveland. Apparently, he didn't show insurance when that case was resolved in 2016. Judge, years later, he did show insurance to the court, and that's marked on the docket. That's attached to my motion. However, the B&B at that point had already, or should have already, suspended him unbeknownst to him. So, Judge, years later, he gets this driving under suspension in Cleveland. They tow his car as a result of that charge. His car is still in the city impound. He cannot afford to get it out. He's been accruing fines daily. So, Judge, it's a unique set of circumstances in that, he picks up this case due to this 4-year-old headlight case, which he, just to be clear, paid his fines and costs to this court. So, Judge, what I'm asking for, and I spoke to the B&B and they said they're happy to do this. They just need a court order. Judge, what I'm asking for, very humbly, is an order to vacate his suspension with the B&B and an order to the city Cleveland impound lot to waive his fees, impound and storage fees, because he cannot get that car out. Essentially, that car is going to be forfeited to the city unless the court grants the relief we're seeking. Thank you.
So just to be clear, you had a conversation with the B&B.
Yes, sir.
And they agreed that by order of this court, they will vacate a previous suspension. Is he under suspension now, or is it a previous suspension?
He is under suspension now, Judge. And so I spoke to Darlene Jones. She's the regional representative for the B&B. And her position, the B&B's position, is frankly, they don't care. They're happy to vacate it. All they need is a court order to do so. Okay,
so that's step one. Ms. Johnson, question. Because I know you're a B&B expert, or used to be, or is that something that's been done, or that you've noticed done, that court we would order a suspension to be vacated? Ms. Johnson has a lot of history with working with the B&B on the back court. So, Ms. Johnson, have you experienced that? Basically, that through an order of the court, they'll vacate an old suspension.
They have done that if there's the proper paperwork is set. There should be an order that you guys.
One of those orders. All right.
If
So
it's not on there, they can just write it in.
okay. So that's not an issue. All right. Now, that's the easy part. The more difficult part is even dealing with East Cleveland. I've yet to come across a case where it's been that I've ordered the impound lot to vacate any fees or fines or costs, only because I don't have jurisdiction over the impound and their business. Like, for instance, in East Cleveland, it's a separate company altogether. So what I've done in this particular court is that if there's an issue with a car being towed and police being involved with that, I've directed people to the city because of the relationship between the city and the tow yard, and they've vacated or dealt with the cost that way. I'm not aware that I can place an order in effect that would order the Cleveland impound to vacate the fees.
So, Judge, I appreciate that concern. My argument would be that the car was towed and impounded because of a suspension that did incur as a result of allegedly failing to show insurance in a case that did happen in East Cleveland. So,
Okay.
But for that case, but for that suspension that we would argue was imposed erroneously, that car would have never been towed and impounded in the first place.
But now
that does give the court the jurisdiction.
Now, the problem with that is that the docket that I have here says that he showed insurance, unless I can look a little further, in 2019.
That's correct, Judge.
The case of,
delayed in showing that.
right. So if he did he have insurance in 2016?
So, Judge, he believes that he did. Now, I called personally, spoke to his insurance agent. They couldn't find a record of it. So,
See, that's what we would need, because otherwise what I would assume is that Cleveland would come back and say, okay, Judge, we'll vacate it, and then East Cleveland owes us that money. You know what I mean? They're not going to, I can't imagine, unless there's some other negotiation that I think you may be able to accomplish. And if you can do it, I'll sign off on it. But I can imagine that if I place that order in effect, they'll say, okay, if you're saying East Cleveland made an error, then East Cleveland owes us for all the time that he's been, his car has been there. And that's what I would have a problem with, because he didn't show insurance to East Cleveland until 2019. So I would then be taking responsibility for something that happened 3 years ago, like you said, or 3 years prior to that. So I can easily do step one. Now, if you want to continue to work with Cleveland, and if there's something that, you know, through your work as an attorney that you can negotiate with them, that they would zero that out flat out. If there's some order or some agreement from the court, I don't mind doing that. But I don't want to take on the responsibility on a hope that he showed insurance back in 2016, when, like you said, we have no paperwork to show that.
Judge, so I understand that concern. I certainly would not ask or even risk the city of East Cleveland being on the hook for that, whatever that amount of money might be at this
Right.
point. And so I understand that. Judge, the only thing I would say, and I did attach proposed orders for both of the BMD and for the that are attached to the motion. Judge, I feel that if the impound got an order from the court ordering it to waive those fees, I don't believe that legally or otherwise that impound lot can just say, okay, well, we'll do it, but give us the money. I mean, I understand the fear or concern that could happen. It seems to me very unlikely, and obviously I don't have a representative from the impound unit here.
Yeah, what I would do, I would say that on that second order, I would want to wait and look into that. Even if it's just a matter of, you know, determining through the city of Cleveland and their judges that they've even done that. You know, because even like I said, here I wouldn't do that. Here I would not get involved in the financial relationship between the city of East Cleveland and the impound lot that's a separate contractor. So if the judges in Cleveland have done that and it has not come back on the court, and if it does not come back, if you can, you know, through some information other than your word, which I appreciate.
Understood.
I don't want to get us into a point where there's a hope that there's no liability. I'd rather know that for sure. And then I have no problem looking out for Mr. Morgan, but we have to at least cross that bridge. So I can deal with the first one. Ms. Johnson kind of signed off on that, so I don't have a problem with that. The second one, though, I think we'll need to readdress that. And you can speak with my bailiff. All right. So I'll get that first one executed for you, and then we'll go from there. And matter of fact, you've talked with Bailiff Sanders.
Yes.
Stay in touch with him, and then we can reset it when we need to.
Thank you, Ron.
All right.
I appreciate that. And Judge, as far as that first order, do we go to the clerk to get a copy of that, or how should we?
Bailiff Plummer will help you in a second with that.
Thank you, Judge.
All right. You're welcome.
Should we wait outside then?
Yes,
Thank
absolutely.
You, Your Honor. Nice to see you.
Take care. Right. Right. Nerman Abdick, 18 CRB 00157. Good morning, sir. So, Mr. Abdick, remember we're here on a previous not guilty plea. The charge is an assault. They're alleging that you committed that offense in the city of East Cleveland, which is a first-degree misdemeanor, which means you could get up to a $1,000 fine and 6 months in jail. It looks like the attorneys are agreeing to a continuance because they're still trying to get more evidence, correct?
Yeah, they couldn't seem to have found my file
Okay.
before this court date.
All right, so let me give them a chance to get all that together. That way your rights are protected and we know everything that's going on. So I'm going to set that out for February 20th at 9:30. That should give everybody enough time.
What day is that? Is that a Thursday again?
February 20th is on a Thursday.
And I know I requested this before, but there's no way to do it any earlier than that, just because I've missed a lot of days of college because of this case.
No,
I would like to get it resolved.
Well, the problem with that is if I bring you back next week and they don't have it, it'll be continued again. I'd rather give them the time to actually try and get this information so that we don't have to continue it again. So let's keep it on that 20th date at 9:30. All right. We'll see you back then.
And what if on the 20th they still don't?
Well, at that point, talk with your attorney, and she may have some unique way of trying to get it resolved at that point. There's several things she could probably do at that point if they're not cooperating with her. But I'll let Ms. Conwell or whoever's here to represent you make those arguments to the court.
Okay, thank you very much.
All right, you take care. Really? She Shakita Lambert. Excuse me, Shaquita. And how's your last name pronounced? D'Ampert. And that's 20 CRB 00053 from June 22nd, 2019, alleging an assault. Specifically, they're stating that on that particular date that you did cause physical harm or attempt to cause physical harm to a Dominique Jones by punching her in the face with a closed fist. It looks like what I have here, after you spoke with the attorney, you are going to enter a plea of not guilty at this time. And that means we'll set it for a pretrial so the parties can exchange information, see what evidence exists. And that date will be February 20th at 9:30. All right? Thank you. Bailiff Plummer will give that to you, and we'll see you back at that time. Take care. Sharia Shanette, 20 CRB 00056. Good morning. All right, Ms. Shanette, it looks like in this particular case, you were charged with criminal damaging. Where they're saying that a door was broken at the Marathon gas station. And this allegedly occurred on or about January 10th. From what I see here, that you were ready to resolve the case by entering a plea of no contest, and then you were going to request to be entered into the cycle breaker program, which upon your successful completion of the program would result in the case being dismissed against you. Is that your understanding? Okay. All right. So basically what happens is the program, it's a 6-month term of probation. There are normally within that period of time, 2 different programs that you can complete. The first one is a women's empowerment program that talks about leadership skills, self-awareness, and all those things. And the other one is an anger management program where we make sure that you have tools to make decisions so that you're not even charged with these types of cases. Most of those are in the evening. The ladies program specifically is in this courtroom on Wednesday nights at 5:30. Mr. Medley, do you know when the anger management program takes place? Thursday morning. Is there any evening programs for that?
There's one Monday.
Okay.
Yeah, they can be working.
All right. So that's basically it. And the key is once you complete those, the benefit that you get is it's first degree misdemeanor doesn't go on your record. So are you still ready to enter that program? Okay. There is a fee for the program, and that's $425, but it covers your expungement and you have time to pay it. So you don't have to pay that right now, but over the course of the term of probation. Last thing I will mention, if you're doing everything, excellently, and you're hitting the classes, you're reporting, oftentimes they present to me to ask for someone to be let off the program a little early. The opposite happens too. If you're not doing what you're supposed to be doing, they can ask for it to be extended or for you to be kicked out of the program, which would result in a conviction on your record. So it's a good opportunity. It really is. So to get to that point, how do you plead to the charge of criminal damaging? It's a no contest plea? All right. And what I do is I hold the finding in abeyance, meaning I'm not going to find you guilty at this point. I'm going to give you an opportunity to make it through the program. I'm going to give you a piece of paper that's going to have the information on the program for you. Bailiff Sanders, what day is she going to meet with probation? February 10th. So the only other date that I'm going to give you, and you'll speak with Mr. Medley, is the day that you set all this up through probation. We normally set the dates from the bench is 10 o'clock on the 10th. You can speak with Mr. Medley if there's something that you need to adjust in that regard. He can work with you, all right? So I'll give you that information. You'll see Mr. Medley, and we'll go from there. Mhm. Just that. Thank you. Mariah Clark. Ms. Clark is 18 TRD 01265 from May 27th, alleging a driving without a valid license. At the time, it looks like they may have been forfeited. They marked no for insurance, but you've shown it, and the city has agreed to amend your charge to failing to display your license. Is that your understanding? All right. So to that amended charge, how do you plead? Okay. I'll accept the plea with the finding of guilt based on the information on the ticket. And as opposed to the $500 fine, I'm able to cut it in half, so it'll be $250 plus costs. You just go to the clerk's office. All right, take care. Marquita Woodard. All right, Ms. Woodard, I have two cases. One is 17 TRD 02957, a driving under suspension and a plate violation from December 9th. I'm sorry, it's three cases. Then I have an 18 TRD 00165 from January 21st, 2018, expired plate. The 2018 case, it looks like it's going to be dismissed by the city prosecutor. On 17 TRD 02957, you were going to enter a plea of no contest to no driver's license, and the other charge is going to be dismissed. Is that your understanding? All right. So let me hear that from you. How do you plead to no driver's license? I'll accept that plea with a finding of guilt based on the ticket indicating that you were a Superior and Emily driving with a suspended license on December 9th, 2017. And the other charges will be dismissed on that particular ticket. And then I have 20 CRB 00095 from January 31st, alleging an assault violation that you are maintaining not guilty on. And basically that complaint is stating that on or about January 31st of this year, you did knowingly cause physical harm to a Miss Jones by pulling her hair out. And again, that is a first-degree misdemeanor, which means you could get up to a $1,000 fine, 6 months in jail. So we're going to set that for they're requesting a trial, but I will note that because it hasn't been tried yet, it could be continued, but I'll set it for a trial as being requested at this time. Okay. What's the trial date? Because you know this is probably going to happen. Or is this going to be held into that? And then I have Mr. Medley from our probation department on 17 CRB 00954. This is an older case. And Mr. Medley, I believe you're standing because there must be an issue with probation, correct?
Yes, Your Honor. She's currently in violation. She was placed on August 17, and she had a couple programs to complete. She did complete one, but she never attempted to finish first. And she last reported February 2nd of 2018.
Who was your probation officer? Okay. All right. So, Mr. Medley, let's do this. Let's go ahead and set this trial date since there's still probation active, correct? Technically, she's still on probation, right?
She's on probation, she's in violation.
All right. Either way, let me say this for sure. There's a trial request. February 20th is when we're going to come back on this new case. So basically what's going to happen, the court's going to shift the focus on this new assault. We can deal with the probation issue because we'll still have you present. And at some point we'll put it all together, but let's deal with the not guilty right now on this new assault charge. I'll note that we had information from probation stating that you didn't finish one of the programs and you didn't report, though you did finish one. All right. So we'll get you back on track in that regard, but let's put everything on hold and deal with this new case. So I'll see you on February 20th, all right?
20, okay, because I was about to say what did this.
Yep, February 20th at 9:30.
Okay.
Can you make it out? All right. Take care. Say don't turn it. Jennifer Hales. Good morning. All right, Ms. Hales, let me start with the cases that look like they're resolved. 19 CRB 01287 is from October 5th, 2019, alleging that there was a violation by you being in possession of some type of drug paraphernalia. It looks like based on maybe your resolution of the other cases, the city's going to dismiss that particular case. Then there's 19 CRB 01294 from September 21st, 2019, where there was an allegation of telephone harassment. We had already entered a plea of not guilty, but it looks like now the city is going to resolve that by dismissing the case. And then we have some other cases. All right, 19 CRB 01295 is from September 28th, a menacing by stalking that the city has dismissed. And that leaves us with 19 CRB 01296 from September 21st, 2019, an aggravated menacing by stalking and telephone harassment. Madam Prosecutor, can you articulate on the record your resolution of all these cases?
Yes, in exchange for Ms. Hale's plea to one count of menacing by stalking and one count of telephone harassment, the remaining aggravated menacing charge on that case would be dismissed, and the other three cases would be dismissed as well.
Right. And do we have a victim present?
We have both victims present, so.
Okay. Do the victims want to speak at all? All right. So, Ms. Hales, you understand what's being offered by the city, correct?
Right.
That you are going to enter a plea of no contest to an aggravated menacing as well as telephone harassment. And with that being the agreement, the other charges were going to be dismissed.
Correct.
But those two charges, you face the possibility of a $1,000 fine and up to 6 months in jail on each one. You understand that? All right. Any threats or promises to get you to enter into that plea?
No.
All right. So how do you plead to the aggravated menacing?
No contest.
And how do you plead to the telephone harassment?
No contest, but I would like to make a statement before I sit back down.
Your Honor, if I may.
Yeah, you can. And even for Ms. Hales, I appreciate that. Normally what I do is I allow the city to make their statement first, so you will have to sit back down. I'll call you back up in a second. So have a seat. Ms. McCullough, go ahead.
The victims in this matter are Monique Sharp and Llewellyn Hill. Both parties are present. There it is. This has gone on for several months, really over a year. And during that time period, Ms. Hales, after a breakup with Mr. Hill and his relationship with Ms. Sharp, Ms. Hales went on a campaign, essentially, with both parties. She created a fake Facebook page. She then friended their friends, and then she began to send the messages. She would screenshot. She took a screenshot of a common pleas court docket, civilly, but still, and then posted that so everybody could see what was going on with Mr. Hill. She's made numerous threats. She sent them voicemail messages threatening to blow their heads off, depending on how she felt that day. I'll send, I'll let the court peruse through these. They believe that she rode by the home and shot at it. She has gone to bars that she thought that they might be at and waited and hoped that she would see them. She contacted people that they knew and offered them $100 to let them know where they would be. She bought tickets to sporting events just so she could see them. It has gone on and on and on and on for quite some time. It has gotten extremely ridiculous and downright dangerous at times. The parties have got to the point where they don't know what to expect. They're concerned. They have, Mr. Hill has children, and he's afraid to even mow his lawn at times because he's not certain what she might do. Let them take it from
Okay. State your name for the record, sir.
Welling Hill Court.
All right, go ahead.
Yeah, like I say, Ms. Hill is a great behavior and have no edge. She know my work schedule, and when I work night shift, that's when she does her most.
How long had the two of you been together?
Jennifer and I,
Yes.
we messed around for 3 years.
Okay. All right.
We
And
never lived together. Nothing.
and these events started happening after the end of the relationship.
Absolutely.
Okay. All right. And just so I'll know, and I do have a lot here from the city. The first thing I noticed, obviously, is the pictures of weapons and the hole and all that. So you're under the belief that your home was shot at. Is that correct?
Yes.
That's not me.
Okay. All right. That's fine. That's fine. Continue with your statement. Then we'll hear from the lady.
Well, one more, y'all. Three shots in my house.
Okay.
And she left voicemail after she did it. Yeah, witnesses, our daughter, to subpoena. Everybody was there. Our stepdaughter, well, my stepdaughter, her daughter, is in the Shaw band. Shaw band just got out of practice. 4 of the little girls come up to the house. They was there also when the shooting took place.
Okay. All right. Ma'am, go ahead. State your name for the record.
My name is Monique Sharp.
Okay. Ms. Sharp, what would you like the court to know?
Jennifer Hill was welcoming me. She said I was the cause of her breakup. She put notes on my car. She came past the house one day when I was outside and she's like, oh bitch, I've been looking for you causing me a breakup. So I said, okay, I'll be right back. So I went into the house, I called the police came. Those pictures on there when the police came and arrested her. And she thought he was home, but he wasn't home. He called a flat tire that morning. I took him to work and his car was there. So she assumed he was in the house. And I was outside, taking up for him, defending him, which, and just like she left several messages on my phone, saying she gonna kill me, blow my head off. And one day she put a post up. She was at my daughter's school. I had to leave work, and she had like a gun with a stack of money, making threats like she was at my daughter's school, going to do something to my daughter. My daughter called me like, mommy. I saw her. She ran back in the house. She stayed right there on the corner of the terrace, the corner house. So my daughter ran back in the house. So I told her I had to call my her stepmom worked at Shaw. Somebody to come look at her, make sure nobody pulled her out of her class or anything. And I came back home, went to Shaw. They said she was fine, and she still been coming out of the house.
Okay. Ms. McCullough, anything else on your part?
I think the gist of it on the pictures and the text will tell the rest.
All right, you can have a seat. Thank you.
Oh, one more thing.
Go
She said I called her house. I called her phone. There's some papers in there. When the police came, it's like by the message, when you push play, right by play, it's called. So I accidentally call her phone, but I never left no message like that or nothing on her phone. So you'll see those in there too. It's a 911 call and not call.
All right. Thank you. You can have a seat.
Thank you.
Ms. Conwell, I know you wanted to make a statement, and then I'll have Ms. Hales come back up.
You know,
Ms. Hales, come on. Go ahead, Ms. Conwell. You can go ahead.
I will concede to the fact that I don't have it as extensive of information as the state does. However, I do, after having the conversation with
Yes.
yeah, Ms. Hales, okay, I couldn't think of your last name, Ms. Hales, I understand that she is undergoing therapy at this particular time, is that right, Ms. Hales?
Yes, after, this hasn't been going on for over a year. This occurred in September. I was in a 3-year relationship.
Ma'am, you have to sit down.
No.
Ma'am, you have to sit down.
That's my witness with her statement. But this has been going on actually since September, when I was in a 3-year relationship and found out that I was basically being used by Llewellyn for my money. I gave him money for his boat. I gave him, when his car was repossessed, I gave him $800 to fix his hoopty so he could go to work. I gave him $400 for his daughter's prom and graduation because he could not afford that. And through the entire time, he lied to me for 3 years about his relationship with Miss Sharp. I have all those text messages. Even in September of last year, him telling me that she's not the one. He's not with her. He isn't in a relationship with her. So when I got off of work on, I think it was September 21st, I drove past his house and her car was present. And at that, he had just been texting me all that day, all that night. And at that time, I knocked on his door to confront him because he's been lying his way out of everything that he said about her. And that's when they came up and pressed the charges on me, saying, because I confronted him at the house. I've been pink slipped over this. My therapist has diagnosed me with PTSD over the trauma of everything. I have currently a civil suit for intentional infliction of emotional distress against Llewellyn. My therapist also sent a letter to the court to let you know everything that's going on. I've had to apply for FMLA with my job because I was homicidal. I was locked up in the hospital for 6 days and put on medication before they would let me out. I'm on 3 medications now to deal with my anger and to knowing that I cannot force accountability on someone that was a manipulator and a deceiver. So I do have that lawsuit, which I plan to, with my witnesses and all the text messages from him all the way leading to that time, and as well as with my medical documentation for everything that I've gone through with this, I feel like I'm gonna have a very solid case for intentional infliction of emotional distress. I also have a request for production of phone records because on September 24th at 11:32, December 10th, which was last month at 9:41, December 11th at 5:09, December 11th at 5:10, the plaintiff Monique Sharp continued to call. She's calling me. And when I call her back, she sends my phone calls to voicemail, which forces me to respond to her by text or leaving the voicemail. But I asked for a production of her phone records for her outgoing phone calls for these specific days and times, because what she's doing is spoofing my phone. She dialed *67 first so that her number appears private. So I don't have the documentation showing that she's calling me. But on December 10th or December 11th, they actually came up to my job and tried to file a police report I work for the VA, I've been there 20 years. And they tried to file a police report with them saying that I was harassing them. So I got called down, I was questioned, nothing came of it. But when I left work that same day, she began to call my phone over and over and over again. Every time I would answer it, she would be in the phone laughing like, that's why you're gonna lose your job. And before I could say anything back, she hangs up.
Ms. Hales, let me do this because out of respect for everybody, and especially you, obviously there's a lot to this.
Yes.
And what you've entered a plea to could subject you to 6 months in jail and a $1,000 fine on both of those charges. But based on everything that you've said to me, I believe it's more appropriate for this court to do what's called a pre-sentence or pre-resolution investigation, where you talk with our probation department. That way, all that information that you have right there will be presented, will be reviewed. That way I'll have an entire picture of what's going on. And we will set a date for a sentencing where we will actually resolve that. At that, two things would happen. Prior to that, any witness that you have can speak with probation if you give them the permission to. And at the sentencing, you can have any witness present to me. But I think that's the more appropriate time because of so much being involved and the fact that there's the possibility of jail time. This is not the date or the day that I would make that decision because there's too much involved here. It wouldn't be fair to you to do that. Right. So let me set this for a formal hearing where we can take whatever time we need to have everything presented so the court can figure out what's the best resolution. And when you speak with probation, I think it's very important that you're open and honest with them in regard to whatever treatment and all that that's going on, because all of that, and that's obviously is a part of what I need to know. So I'm going to set that date for February 10th at 3 p.m. So that's Monday at 3 p.m. You will come back to City Hall through the front doors, down the stairs to the left. But before you do that, you're going to see the gentleman to your left, Mr. Medley, so he can give you more information. All right. So we're going to do that on that date so I can give you the adequate time so we can discuss everything. All right.
Yes.
Any questions about that?
No, I just.
Okay. And that's important. And you're also able to come back on that date. And I put a note here is that the probation will be in touch with Ms. McCullough so that in the event that you wanted to provide a statement to probation, you could do that too, but it'll be through contact from probation. So we'll keep everybody in the loop. The date for you meeting with probation will be the 10th. Ms. McCullough, I don't have a court date yet until they give it to me. So I'm sure I put here to keep in touch with you so you'll be able to let the other parties know when to return if they would like to return. So everything is being paused right now. We have a plea, and now it's to the next phase, which is the resolution of it, okay? All right. Yes.
One more thing. Just when on the 11th, when she kept calling me, I was talking to my mother on the phone at the time she called. And when I answered with my mother on freeway so that she can overhear what Monique Sharp was doing and saying at that time. So I have the witness and witness statement for that as well.
Okay. And I'm going to hear from you. And keep in mind now, these types of cases aren't new. I will say all that's involved and all that I'm being presented with today, goes high up on the scale of a worst case scenario when there's, pictures of weapons and allegations of gunfire and things like that. I don't doubt that there has been some type of back and forth. I mean, that's human nature. But when it gets to the point where there's, harm and threats of harm, serious threats of harm, that's another level. So I am interested in the cause, but I'm also, very concerned about pictures of weapons, pictures of holes in the house, threats of harm. That's really troubling to me. But even still, let's do this in the proper form so I can have a proper context of everything that's going on and where we are now. Councilor.
I think Ms. Hales got to add that she's in a master's program. Yes, I complete my master's in microbiology next semester. I actually have an interview with the CDC for a job starting off at $90,000, and I'm pursuing my PhD. So I feel like I have so much to offer, whether to entertain people who don't have anything near what I'm trying to achieve right now. I would just like to get this over with.
All right, that's good information for me to know. Make sure Mr. Medley has that information as we go forward also. Okay. All right, you can step down there. Thank you. Madam President. Let me just, which one? Tommy Pratt. Is it just on probation? Is it probation? Mr. Pratt, good morning. Okay, Mr. Pratt, this was set for a resolution in regard to sentencing. What I'm going to do in 19 CRB 01322, based on the information I have here, I'm going to keep the no contact order in place. You understand that? So we're going to have to arrange for you to find another place to live. Have you been working on that, or where are you in that regard? Okay. So the no contact order will stay in place until I lift it. I'm gonna have you I'm dealing with probation. Now, keep in mind, I could have given you up to 6 months in jail. Right now, I'm opting not to give you any jail time. I'm gonna have you on 2 years of probation working with Dr. Williams in our domestic violence program, as well as our anger management program. As long as you maintain the no contact and continue with what we're trying to do to give you the skills to be able to, you know, deal effectively with your family, you won't face the jail time. But if you're making contact against my order and or missing the programs, then you're looking at the possibility of 6 months in jail. You understand that? You have to say yes. So what I have to do is set a date for you to meet with probation. Baby, what day will I set for you? It'll be Monday, February 10th at 9:30. Mr. Pratt, where have you been living since our last hearing? Give me 1 second, because I'm gonna put something in your hand. You say, so you've been just various places? All right. Are there certain items that you need to get so that you can spend more time away from the home? I mean, are there things there? And you don't need anything from there at this point? All right, so it's being sent, you were told? All right. Okay, so again, the key, I looked at everything. That's how I'd rather handle it, as opposed to saying, okay, I'm gonna send this brother to jail. I know you sat down in the jail. I'd rather work on getting you back on your feet, even if we need to help with you getting a more permanent residence. That's part of building you up. It's not just to have you doing stuff, but it's also to put you in position. So I'm gonna have you meet with probation on Monday at 9:30. We'll give you a piece of paper, and you can go ahead and mark it in your phone. You'll see Mr. Medley before you leave.
So what if I got time I have to come see them? Then I gotta go down. If I got to see my felony probation.
So what you're saying, going forward after Monday?
Yeah.
Because you don't have you're okay for Monday, right?
Yeah, I'm good.
Yeah, we work with you. That's not a problem. We work with you. We don't try to interfere with any other court appearances. We can make sure we work around that. All right.
What time?
It's going to be 9:30 on Monday.
Okay.
And this is, you have an appointment
Well,
already?
you know what? I can work around that. Yeah,
Okay.
9:30 is fine.
All right. Any other questions?
Sorry, for-
This is 2 years probation.
Okay.
And he's working with Dr. Williams.
Okay.
The no contact remains in place. And I'll put it in a journal here for you. I'm good. Yes, sir. Yeah, you can step right down here. Check it out. Look. Oh, you are. You was on time. No, is it just one count? That's two. Yes. But you know that when those happen, you gotta let them know that's a violation of your expectations every single time. You know what I mean? Because obviously. Yes. I think you guys agreed to an amendment to the assault. Yeah.
Thank you.
You're welcome.
No.
Oh yeah, that's it. Well, he said something coming through the door. Raniero Blakely. Mr. Blakely, we have 20 TRD 00360, traffic violation for driving under a suspension, failure to use your signal, and no insurance. You're maintaining not guilty on that, it's my understanding. Correct? You're gonna work to get your license back? You know everything? Okay, you know what you need to do to get your license? So what you can do is, I'm gonna give you a court date for March 18th. That'll give you a chance to contact the BMV so that you can work on getting your license. And the other thing is that if you do have insurance, if you come back and you're not able to get your license, at least with you having insurance, I don't have to resuspend your license. You know what I mean? It still puts you on track. So find out what you need to do. If you come back with your license, what you've noticed is that it at least cuts your fine in half. You know what I mean? It saves you $250 and no points on your license. So it puts you in a good position. So it is worth the shot to try and get in between now and that time. All right, we'll see you back on March 18th. Oh, I'm sorry. There was a probation case too. You're on probation, Mr. Melly. Do you know that you have Mr. Blakely's case?
Oh, yes, sir.
All right. Thanks. Sir. That probation case is 14 CRB 00253. Mr. Medley?
Yeah, he was in violation here.
So
he had a case, he had a particular case, it was attempted murder. He's here, he spent time at the correctional facility. He just never, before bringing these papers, he never reported back.
all right, so Mr. Blakely, 2014, we had a case of carrying a concealed weapon and some possession. So tell me what happened since that time? Okay. So you spent about almost 3 years? All right. What did you end up pleading in that case? Okay. And how old are you? All right. And so you got out when about? So what have you been up to since you got out? Okay. Are you working or anything? All right. What city are you living in? All right. So a couple of things. So this case is 2014, which obviously was before you got into the more serious trouble. You did time on that. So a couple of things I'm thinking. You owe a balance on that old case. So my first thought is, first of all, on probation, because you've ended up doing time on something more serious, I'm going to go ahead and get rid of probation in that case. But what I would also like to offer, because oftentimes, like you said, you're done with that, you come out trying to stay out of trouble, trying to get a job. That's a challenge. That's an uphill battle. What I would like to offer for you, because believe it or not, I care about you being, the best you can be. We make mistakes, but we can come back from them. Some mistakes are worse than others, but the bottom line, as long as you're living, you have a chance to come back from that. So what I will do for you, I say all that to say, I don't know if you remember, but Monday nights in this courtroom at 5:30, I hold a program called Finish First, and it deals with leadership skills, just giving you tools on how to get back on track. Every time that you come to that class, what I'm gonna do is, because you don't have to, because I'm ending probation because you did time, but every time you come to that class, I'm willing to take off at least $75 to $100 off of what you owe me. So basically, I'll be paying you to come and get some skills so that you can just get yourself in the best position to win going forward. I'll take note of that. All you have to do is sign in. I'm sure you'll remind me if you do it. Hey, Judge, because right now they have you on us $660. I'm willing to let that go all the way down every time you come to one of my leadership classes, all right? So that's that on that old case. On the new case, I'm giving you a chance to come back with your insurance and try and get your license, all right? Any questions? You got the reminder in your hand? All right, matter of fact, let me just make sure you have this in your hand too, so you know about the class. It's up to you, but I think it's a good benefit just to give you some tools to get back on track. Other than that, good luck, sir. I'll see you when you come back. Jeremy Furline. 20 CRB 00047 from January 12th, alleging a domestic violence offense. We had already entered a plea of not guilty. We set it for a pretrial. It looks like the parties are going to set this now for a trial for March 5th, right? So we'll set that for trial March 5th at 1:30. I already have the information on the no contact, so I know where that stands. We'll see you back when you come in.
Council, are you ready?
Yes.
No.
She can come sit in. She can come sit.
It's the 5th. Make sure you mark it on there. Fabulous, squiggly. Javon Cooper. Mr. Cooper. 20 CRA 00102. This is from February 1st, alleging an aggravated trafficking in drugs and carrying a concealed weapon. Mr. Cooper, they're charging the drug offense as a felony of the 3rd degree, 9 to 36 months, and a $10,000 fine, where they're saying that on or about January 1st, you had in your possession suspected crack cocaine and bags of marijuana with the intent to distribute. And then there's a carrying a concealed weapon felony of the 4th degree, 6 to 18 months, where they're stating that on January 1st, when you were stopped, you had in your possession a loaded firearm. Good morning, sir. You spoke with the defense attorney, Ms. Conwell, correct? Ms. Conwell, on behalf of Mr. Cooper, in regard to the preliminary hearing, how are we proceeding?
Yes, sir. I think Mr. Cooper will address his rights and preliminary hearings chosen to waive his rights.
All right. So, Mr. Cooper, remember I mentioned that waiving the right to the preliminary hearing is not admitting any guilt. It's just moving the case to the county. How long have you been in jail? Okay. Okay. Detective, on the issue of bond?
Detectives are recommending $20,000 cash or surety bond.
All right. So basically, Mr. Cooper, what I do is I set a bond from this stage to get you from here to the county court. At that point, the judge is going to have your case throughout this duration, can either increase the bond or even lower the bond if the judge sees fit. But this bond is at least between now and your court date, which is February 10th, Monday, 12th floor of the Justice Center at 9:45. Any questions about that? All right. Other than that, sir, good luck. Go ahead.
After this court date, how long would it take me to reach? Since I've been here, I haven't been able to reach your employee, attorney, or make a phone call.
Okay, so normally you would be transferred probably sometime today or tomorrow.
Today or tomorrow.
But what I will say, Mr. Plummer, the gentleman over there, normally after you appear for me and I hear that you haven't made a call, even though Detective Stanford sometimes disagrees with that, I'll make sure, as long as you're working with David Plummer, respectful and all that, he'll make sure you can use a phone. We can get that for you. All right, you can have a seat.
Usually, Your Honor, when they come upstairs, they're allowed to make phone calls in the interview room, sir.
Okay. All right.
Everybody to come upstairs if they wish.
Larry Eason. Mr. Eason, 20 CRA 00093 is having a weapon while under disability. What they are alleging that was a violation of a felony of the 3rd degree, 9 to 36 months in prison and up to a $10,000 fine, because on January 29th, on or about that day, you were in possession, or you acquired or carried or had on or about your person a firearm or dangerous ordinance. The disability is the previous conviction of a felony. You get a chance to speak with the defense attorney, Ms. Conwell, correct? How old are you, sir? All right. Ms. Conwell, on behalf of Mr. Easton, how are we moving in regard to the preliminary hearing?
You already have to speak with Mr. Easton with regards to his rights and preliminary hearing. He's chosen to waive those rights.
All right. So the case will be set for February 10th, which is Monday, the Justice Center downtown, 12th floor at 9:45, but I will give you a reminder. Detective, on the issue of bond?
Detectives recommend a $5,000 bond.
Your bond is being set at a $5,000 surety bond, which means, if you make a couple of calls, you should be able to get out. If not, you'll be sent to the county where you can then post the bond, all right? Any questions? All right, good luck, sir. You can have a seat. Jonathan Dickey, 20 CRA 00110. This is a felony charge of aggravated robbery as well as having a weapon while under disability. They're stating that the weapon under disability obviously is a felony of the 3rd degree, 9 to 36 months, and a $10,000 fine, because they're saying that on February 4th, 2020, you had a weapon on your person after having multiple other convictions of felony charges. So that creates the disability. Then there's a charge of aggravated robbery, a felony of the 1st degree, where you're looking at the possibility of at least 3 to 11 years in prison and a minimum fine of $15,000 as much as $20,000, where they're saying that you did have a deadly weapon on or about your person or under your control and either displayed the weapon, brandished it, or indicated that you possessed it while committing a theft offense. Mr. Dickey, did you get a chance to speak with the defense attorney? Okay. Okay. And how old are you? 26. Ms. Conwell, in regard to the preliminary hearing, how are we proceeding?
After speaking with Mr. Dickey with regards to his rights for preliminary hearing, he still doesn't waive his rights.
All right. So the case will be sent to the county for further proceeding. Your date will be February 10th, 9:45, 12th floor of the Justice Center. Detective from the bond.
Detectives recommend a $50,000 cash and surety bond.
All right, so the bond will be set at cash or surety, $50,000. Mr. Dickey, don't know anything about the case. I'm just looking at what I have here. 26 years old, a lot of life ahead of you, so it's up to you to decide how you want it to go. But I'm just looking at what they have here. At least 2 or 3 other burglaries or attempted burglary and possession of drugs and all that stuff. So bottom line, at 26, I'd rather see you, go in a different direction. I don't want to see you, first of all, hurt somebody, kill somebody, or end up dead, breaking into somebody's house. And plus, in and out of jail is not where you're supposed to be. You know what I mean? You're not born to be in and out of jail. It's just about making a better decision. And regardless of what you've done in the past, once you get past this stuff, is at the time to say, you know what, I'm gonna switch that. I'm gonna go in a different direction. I mean, I'm just saying that because in the event that I don't see you, you know what I mean? You may not hear that downtown. I believe you can turn it around. We all can. It's just a matter of, deciding I'm not doing that no more, flat out. It's gonna be rough because you got a history, but you can make it. You know what I'm saying? But other than that, good luck. You can have a seat. Marlon Butler. Mr. Butler, 20 CRA 00109, fleeing and eluding, having a weapon while under disability. The having a weapon while under disability is a felony of the 3rd degree, 9 to 36 months, a $10,000 fine, because on or about February 4th, when you were discovered to have a weapon, you had previously had a conviction where it looks like there may have been an aggravated robbery. The failure to comply or fleeing and eluding, they charge that as a felony of the 3rd degree, also 9 to 36 months and a $10,000 fine, because they're stating that on or about February 4th, 2020, you operated your motor vehicle in a way to willfully elude or flee from police, creating a substantial risk of harm to other motorists, yourself, or pedestrians. You spoke with the defense attorney about the preliminary hearing, correct? Ms. Conwell, on behalf of Mr. Butler.
On behalf of Mr. Butler, Your Honor, speaking with him with regards to his rights, the preliminary hearing is still no way those rights.
All right. So, Mr. Butler, same thing. I'm gonna set your court date for Monday, 12:45, 12th floor of the 9:45, 12th floor of the Justice Center. Detective to the bond.
Detectives request a $25,000 cash and surety bond, Judge.
All right. So we're gonna set that bond, and keep in mind again, once you get downtown, the judge can adjust it up or down. Okay. But other than that, good luck, sir. (20 CRA 00108), Annette Harris, aggravated robbery and having a weapon while under disability. And then there looks like there's an old driving case from 2017 that we're going to get resolved. The cases I have that are felonies, the having weapon while under disability is a felony of the 3rd degree, 9 to 36 months, and a $10,000 fine, because they're alleging that you were previously convicted of multiple drug offenses, and at this particular time when you were stopped on February 4th, you were in possession of a weapon. And then there's aggravated robbery, a felony of the 1st degree, 3 to 11 years, a minimum fine of $15,000, as much as $20,000, because they're saying on February 4th, 2020, you had a weapon on you, you brandished it, or indicated that you possessed it while attempting to commit a theft offense. Ms. Harris, did you speak with the defense attorney about your preliminary hearing? Ms. Conwell, on behalf of Ms. Harris.
On behalf of Ms. Harris, Your Honor,
Detective, on the issue
Judges
of bond.
recommend a $50,000 cash or surety bond, Judge.
All right. So again, keep in mind, you're not giving up any rights other than to have a hearing. You're not admitting any guilt. You're still not guilty at this point. We're just moving it to the proper court. That date will be on February 20th, 12th floor, 9:45 of the Justice Center. We'll set the bond at the $50,000 surety. Any questions, ma'am?
I'm just wondering why mine so far away, everybody's pretending that's 20th.
What, your court date?
Yeah.
No, your court date is Monday.
Okay.
Yep, I'm sorry. I want to make sure that's clear because
The 20th.
yeah, I'm sorry, because I don't want you to miss that, because then that'll be on me. You go down there, you're on the 20th, and they're gonna make your bond $100,000 because you missed it. No, it's Monday, February 10th, and I'm gonna put this in your hand too. 12th floor of the Justice Center at 9:45, so you'll have it in writing. But I'm glad you cleared that up. All right, you're welcome. Good luck. Oh, on this other case, did you want to resolve that 17 TRD 02977? That was from December 12, 2017, you were driving without a valid license. Remember that? All right, you were going to plead no contest and no driver's license. Is that correct?
Yeah.
All right. So what I'm going to do with a no contest plea, I have the option of finding you not guilty. I'm going to do that. You have bigger issues to deal with. So that case is gone. Good luck going forward.
Thank you, Rob.
Thank you, Detective. I appreciate you. Brett Swinger. 19 CRB 01486, failure to comply with an order of an officer. We're going to hear from the city because it looks like the city is going to dismiss that. And then we have 19 TRD 04879, operating in a willful and wanton disregard for safety, is going to be amended to a speeding, which carries 2 points. Counsel, good morning.
Good morning, Judge.
So let's start.
No.
Thank you, Mr. Snow. Nice seeing you again. Counsel, how do you plead to the amended charge that's a speeding in 19 TRD 04879? I'll accept that plea. It's a $200 fine. That's the easy one. Yeah, go ahead. Well, we also have that other case that I want to hear some really good details on that one because it looks like it's going to be dismissed. And they were both connected, correct?
Yes.
All right. So, Madam Prosecutor, let's go on the record of 19 CRB 01486. Give me this city's position.
At this time, in exchange for a plea to speeding on the traffic, the failure to comply will be dismissed. This case came out of the day that they had the vigil for young Tamia Chapman, after she was killed during the Cleveland police chase.
Okay.
They had set up a vigil for her, and they had blocked off an area for her. I think this was around the time of the funeral. And there were some dirt bikes that were coming through. Now, Mr. Swinger was not initially a part of the group, but according to the police, at some point he admitted that he did kind of join them. So he's at the rear of the pack.
Okay.
So they're going through this area while this is taking place. And they attempted to stop the dirt bikes, light sirens, all that, and they were ignored. Mr. Swinger was at the back of the pack. So at some point, he slows down unexpectedly, he says, because he was trying to actually follow their directions and pull over. And the police didn't realize that they thought he was just doing a maneuver to get away.
Okay.
And they rear-ended him.
The police did?
Yes.
Okay.
So that's why we're doing it.
All right. Counsel, anything to add?
The prosecutor gave a pretty good statement. I don't usually say anything.
Okay.
But he wasn't a part of that group. he was probably the only adult. He's from Amherst. He's from not around here. And it just happened that he was driving up Euclid on the day of the vigil.
Okay.
And the group surrounded him. And he didn't want to be part of them. The police started pursuing the group. So he turned off. And when he stopped in compliance, unfortunately, they hit him. He's not looking for any recovery. He had to go to the hospital, but he's a man. They're kids. He's 29. They were probably all. He's probably the only one that had a helmet because they don't wear helmets. He was probably the only one with plates, and he was probably the only one that stopped in compliance.
Okay.
So I'm happy with the generosity of the prosecutor. She wasn't there, so she's taking my word for much of what we're saying. I don't think he should be hit with any points. He doesn't mind a fine. He doesn't mind the court costs.
All right.
He's a good driver and he's a family man.
Well, you know what, counsel, that's not unreasonable to ask. I'll go ahead and take away those points. It'll be unsafe motor vehicle.
Very kind of the prosecutor.
All right. So we'll do that for you. Unsafe motor vehicle, no points. Still, we'll do the $200 fine, but no points. So I appreciate you both for that. All right.
Very generous.
So the case is closed. Just go to the clerk's office. And court is adjourned until this afternoon.
Shariah Shinnet. What date?
Civil base.
Okay.
Criminal
We're
damage.
not doing a restitution thing, or are we just getting a?
Which one is that?
That
Oh.
was the girl that back to the marathon and broke their process for.
Oh, yeah. So she's going to be on probation. You can submit the restitution information. Yeah, let's do that. And as long as there's no objection, though, we do have one that objected. We didn't have to. They're doing something else.
Oh.
There was one that objected. What was that?
You not
Today.
today?
Oh, you don't know. You may not know.